get started. And when the attorney pops in, because we only have 4 ladies, so I may ask you to hold her until her lawyer, and when the attorney, until a lawyer gets on. But other than that, I'm ready to go.
All right, just a quick update. We're gonna only have, there's only be 3 females today. I believe Anthony bonded out,
Okay.
so, but we're ready to start.
Okay. Let me make that notation and then we can go. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, and to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, the person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand, please. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's start on the ladies' side with Ms. Evans.
Yeah, right here. Y'all can sit down.
Ma'am, you're charged with 1 count of criminal trespass. The bond is going to be set at $3,000. You're also charged with 1 felony count of obstructing or hindering a law enforcement officer. Bond is going to be set at $2,500 for that offense, and 1 count of simple battery against a law enforcement officer. Bond is going to be set at $2,500. So you're going to have a total bond of $8,000. Do you believe you can post that bond?
Yeah, maybe.
Okay. Your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Are you currently working, ma'am?
Well, I work for myself.
I'm sorry.
I work for myself.
Okay. About how much would you estimate that you either earn in a month or make per hour?
Per hour, $15 an hour.
Okay, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Oh, no, sir.
Okay, ma'am, you're free to go back. Ms. Harris, we're going to hold for your attorney. Ms. Sullivan.
It's coming up, Your Honor.
Okay. Ms. Sullivan, ma'am, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000, and 1 count of battery. Bond is going to be set at $5,000. That's a total bond of $8,000. Do you believe you can post that bond?
Yes.
There's going to be a preliminary hearing date set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back. So Ms. Harris, her lawyer should be zooming on in about 5 minutes. We're gonna switch over to the men's side so we can keep moving. And then we'll come back when Ms. Harris's attorney has appeared.
Yes, sir.
Mr. Allen.
Yes.
Sir, you're charged with 1 count of driving under the influence of alcohol to the extent that you're a less safe driver. Bond is going to be set at $5,000 for that. 1 count of violation of Georgia seatbelt law. Bond is going to be set at $500. 1 count of defective equipment. Bond is going to be set at $500. And finally, 1 count of driving a vehicle with an expired or invalid tag. Bond is going to be set at $500. So that's a total bond of $6,500. Do you believe you can post that bond, sir?
But essentially, Mr. Gonzalez Gutierrez is being charged with 2 counts of aggravated assault, 1 count of theft by taking, 1 count of simple battery, and 1.
Thank you, Ms. Hopgood. Do you have any questions for me, sir?
I do have one question.
Yes, sir.
For the DUI, you said that falling under alcohol?
The charge is driving under the influence of alcohol to the extent that you were a less safe driver.
Oh, okay. Okay.
So please don't discuss facts of your case.
I was just trying to understand the charge. They told me a different charge. That's all.
Okay, what were you told?
It was because that wasn't. It was supposed to be for marijuana, under the influence of marijuana, not alcohol.
So it is written that way on the bond order, but on the actual warrant, it says DUI less safe. So what that means is that the allegation basically is that you were under the influence of some substance to the extent that it made you a less safe driver. So you need to discuss that with your lawyer. Do you want me to determine if you qualify for the appointment of a lawyer?
Yes.
Okay. I'm going to find that you qualify, Sarah. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Okay. All right, so let's pause on the mail side for a minute. We have Ms. Hopgood here for Ms. Harris.
Judge, I'm very sorry, but if you could give me 5 minutes, I'm in another courtroom right now, as you can hear in the background. So I'm sorry, Judge.
No problem. Just wave your hand when you are ready. We're holding, I knew you were coming, so we were holding for you to appear for Ms. Harris. Okay, let's switch back over to the male side. Mr. Austin. Sir, you're charged with one count of driving one count of driving a vehicle with no insurance. The bond is going to be set at $1,000. One count of violation of Georgia Controlled Substance Act, simple possession, bond is going to be set at $3,000. That's a felony offense. And one count of possession of marijuana less than an ounce. The bond is going to be set at $1,500. So that's a total bond of $5,500. Do you believe you can post that bond, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. All right. You're free to go back if you don't have any questions.
Thank you.
Okay. Ms. Tolles, how are you? Ms. Tolles? Stay right there, sir.
Oh, I'm sorry. I was on mute.
Oh,
Good morning. How are you?
good morning. I was told that we do not need your services for this morning.
Oh, okay. All right then.
So have a good weekend. It was good to see you.
You too, likewise. Thank you.
Okay. Are you Mr. Burrell?
Sir.
Okay. Ms. Hopgood, are you ready to go? Or are you?
Yes, Judge, I'm ready to go at this time.
Okay. Stay right there, Mr. Burrell. Let's bring Ms. Harris up.
And Judge, I'm sorry I didn't have that on mute when I first came in. I was trying to juggle too many things at once.
No, I understand. I tell people I went to law school. I didn't go to computer science. I didn't go to Georgia Tech. So, Ms. Harris, I would normally speak to you directly, but you've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to your lawyer about your charges and your case. You should understand that this is not private. This is a public forum. So anything you say, everyone can hear it. So don't say anything that you wouldn't want the whole world to know. Okay, ma'am?
Yes, sir.
Okay. Ms. Harris, your client is charged with one count of criminal damage to property in the second degree, and it's listed as a felony, and I've set a bond of $5,000 for that charge. She's also charged with theft by taking as a misdemeanor, and bond has been set at $2,000. So she has a total bond of $7,000. I will hear from you as to anything you want to say about the case of your client.
Yes, Judge. Ms. Harris is a single mother of 4 children. She has an 8-year-old, a 6-year-old, and a 3-year-old, Judge. She's trying to start over and start a business, Judge. This is between her and her boyfriend. He is a victim of one of his current cases.
Hold on 1 second, Ms. Hopgood. Deputies, can you turn the volume down on the computer over there with Ms. Harris? Because we're getting feedback. And so it's interrupting the audio. I'm sorry, Ms. Hopgood, go ahead.
No, Judge, I'm just, Ms. Harris is a single mother of 4 children. She's an 8-year-old, a 6-year-old, a 3-year-old, and a 2-year-old. She does live in Clayton County. She's at no risk to flee the jurisdiction. Judge, she's trying to start her life over. She's trying to start a business. The person to which this property belonged is a mother of her ex, she is currently a victim for one of his cases pending here in Clayton County, Judge. And we just asked that the bond, we asked that the bond be lowered, Judge, to a more reasonable amount that she could get. We were asking for a bond of $4,000, Judge, so she can get out and to be with her children and proceed with her life.
Okay, so let me ask you this question, because this is one of my sort of pet peeves, I guess, is the allegation is something that I consider what I would call it willful conduct. Like, as adults, we've what they've put in here is true. We shouldn't be breaking out the windows of somebody's car, cutting their tires and pouring cheese down the gas tank. I mean, I'm gonna have to have you to help me with that one.
Judge, if I can give a little more background situation to this for your honor. What happened was they have had these two people, the victim's son, Mr. Sebastian, have had a history together. He had stolen some of her property. He still is in possession of her ID. The car was broken down. It had been at that place for several weeks. It was not a running vehicle at the time. The temporary tag that they say was stolen, I have received a picture of it, Judge, and I'm not sure if that's even a legal tag at this point. I would not make any assertions as to what it would or would not be, but it does not look legal to me, Judge. And she understands, all the circumstances surrounding it, but there's a lot of background history and information in there. He has been abusive to her. He has caused her much pain and regret. He's stolen her shoes. He's stolen a dog she bought, Judge. He's, like I said, he's still in possession of her ID, and Judge, we understand the circumstances and the facts. We just ask that the lowest bond possible be given for Miss Harris.
Let me ask you this. The other individual, that's the father of these other children, do you know if they have like a custody arrangement in place?
Judge, I do not believe so. Miss Harris, you can answer to that.
Yes, we have a custody arrangement because of the things that keep going on. Last year, my door was like kicked down because of him. Y'all were looking for him. So since then, I found another place last year in December, but like it's still like confusion. And my kids, they still like stay with me, but they go to school from my father's house. He did have temporary custody of my kids because the only way he could get them in school and get their shots and stuff done was to get temporary custody of them when my door got kicked down last year. And they had to get shots, they had to get stuff for school, they had to go to the doctor, and I was homeless at the time. And I was the victim on his case, so I let my dad keep them until further notice. So we're in the process of letting them come back and stay with me, but here we are again, and the guy is threatening where I stay. He's giving people my address, so now I have to find another place to live for the comfortability of my kids, which I'm trying to work on when I get out of jail, because I have applications that I've applied and they're trying to like meet with me to get documentation to give me my keys. I also have a business to run, so yeah.
Okay, Ms. Harris, I'm going to accept the recommendation of your lawyer. I'm going to reduce the criminal damage to property in second degree to $2,000. So that'll be a total bond of $4,000. I'm going to place a stay away provision on the bond to stay away from Tammy Trimble. I don't get involved with the situations with parents with children, although it seems like whatever is going on is not healthy for you. And I would hope that following this, you do as much as you can to keep yourself away from these situations, because it just seems like
It's the
if you don't,
responsibility for the company that I keep, for sure.
yeah, it just seems like it's just going to be leapfrogging people going in and out of jail, and that's not healthy for the children. So Ms. Hobgood, there's going to be a preliminary hearing date set for November 24th at 8:30 in the morning, courtroom 201, but that date will get changed upon Ms. Harris bonding out, and the case will get bound over by operation of law to Superior Court, and then it'll get addressed. Or you will get a notice. Okay.
Yes.
Is
Yes,
there
Judge.
anything else, Ms. Hopgood?
No, Judge, thank you so much for your consideration of this matter.
No problem. You are free to go, Ms. Harris. You're free to go back.
Thank you.
All right. Let's switch back over to Mr. Burrell. Thank you, sir, for your patience. You've been charged with aggravated assault and aggravated battery. I have denied bond at this point. And I placed a stay away provision on the bond for Malik Dowdell. There's going to be a preliminary hearing date set for November 24th at 8:30 in the morning, courtroom 201. Would you like for me? Well, there's also going to be a bond hearing set for December 3rd at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, I'm going to find you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So you said I have no bond?
No bond.
Okay.
Okay, sir, you're free to go back. Mr. Carter. Sir, you've been charged with one count of obstructing an officer. Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Right.
Okay, sir, you're free to go back.
Uh,
Mr. Cherry.
Yes, sir.
Give me 1 second, Mr. Cherry. Seems like my fingers aren't working well today. Sir, you've been charged with one count of possession of drug-related objects. Bond is going to be set at $1,500 for that. You've been charged with trafficking marijuana. Bond is going to be denied. At this stage, I can't set bond on that offense. Possession of marijuana over an ounce, I'm going to deny bond on that. Possession of controlled substance with intent to distribute, bond is going to be denied on that. Possession of controlled substance, Schedule 1 narcotic, bond is going to be denied on that. And another count of possession with intent to distribute, bond is going to be denied on that. I'm going to set a preliminary hearing date for November 24th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for December 3rd at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Edgerton.
Yes, sir.
Sir, you're charged with one count of criminal damage to property in the second degree. It's being written as a felony. Bond is going to be set at $4,000. Do you believe you can post that bond?
Yes, sir, but can I get a bar reduction?
Hold on 1 second. Okay. What I'll do, Mr. Edgerton, is I'll reduce it by $1,000. So it'll be a $3,000 bond. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond to stay away from a Wayana Bassett. Do you understand that?
Yes.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Now, Mr. Edgerton, if you violate this stay away provision, you're going to get charged with aggravated stalking. And there's not going to be a bond set on that offense. Do you understand that?
Yes, sir.
Okay, you're free to go back. Is it Mr. Garricuse?
Yes, sir.
How do you pronounce your name, sir?
Stephon Gary Quiz.
Garricuse. Okay. Sir, you're charged with one count of violation of Georgia Controlled Substance Act, simple possession. Bond is going to be set at $3,000 for that, and one count of possession of a firearm during the commission of a felony. Bond is going to be set at $5,000. So that's a total bond of $8,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a preliminary hearing date set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
All right, you're free to go back. Mr. Haywood. Tommy Joe.
Yes, sir.
Good morning, sir. You're charged with one count of use of possession of drug-related objects. This is a misdemeanor offense. Bond is going to be set at $1,500. Do you believe you can post that bond?
Sir, I think you got the wrong Haywood.
Okay, you are
John Haywood.
John. Okay,
Yes, sir. Yeah, I got two of
okay. I was asking for Tommy Joe.
them. Tom.
Wait, hold on. Give me a second. I do recall. I had placed John Haywood at the end because he was a fugitive.
Right, okay, I got you. What?
So, I mean, we can do John or Tommy Joe, whichever.
Turn around, sir. Turn around. What are you doing? Turn around, right, there you go. Thank you.
Okay, sir, you're charged with one count of use or possession of drug-related objects. Bond is going to be set at $1,500. Do you believe you can post that bond?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. Do you have any questions of me? Okay, sir, you're free to go back.
That's out.
Mr. Hightower, sir, you're charged with one count of unlawful removal of baggage from the airport. This is a felony offense. Hold on one second.
Hey, you cut him off when he talk. You let know what it is.
So I've set the bond at $10,000. Do you believe you can post that bond?
No, sir.
Okay. Your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions of me?
No.
Okay, sir, you're free to go back. Mr. King,
Good morning, sir.
good morning, sir. You're charged with one count of driving a vehicle with defective headlights. Bond is going to be set at $500 for that offense. One count of driving a vehicle on a suspended license. Bond is going to be set at $1,500 for that. One count of simple possession of violation of Georgia Controlled Substance Act, simple possession. Bond is going to be set at $3,000. One count of possession of marijuana under an ounce. That's a misdemeanor. Bond is going to be set at $1,500. So you're going to have a total bond of $6,500. Do you believe you can post that bond?
I'm not sure you get, it's possible I get a bond reduction, sir?
So why?
I'm not sure if I don't know if I'm able to post that bond or not. I'd have to see, sir, if possible.
So the allegation is that you had 18 grams of marijuana and 8 grams of crystal meth. I don't believe I'm going to reduce this bond. I'm going to leave it the way that it's set. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yes, sir, please, sir.
I don't think I have your form. Did you fill out a form requesting a lawyer?
Yes, sir.
King, right?
Yes.
You should have one in there, yes, sir.
Okay. All right. Let me do it like this, Mr. King. Are you currently working?
I was, sir, but I'm not sure after this point. Work is kind of slowing down. I was supposed to start working a new job, but I don't know, due to the circumstances. So not looking too good, Your Honor.
I have this form. I had attached it to Mr. Hightower's warrant. You do qualify for the appointment of a lawyer, so I'm going to appoint a lawyer to represent you. Mr. King, you have to understand, sir, that I don't want to see people sitting in jail, but how you choose to spend your money is up to you. And I'm certain that the meth and the marijuana were not free. So without the meth and without the marijuana, you'd be looking at a $2,000 bond. So what I'm gonna do, sir, I'm gonna do this. Just to move this along. I'm gonna give you a $2,000 bond on the drug charge.
Thank you, Your Honor.
You're welcome. All right, sir, you're free to go back.
Yes, sir. Thank you, Judge.
You go ahead.
Mr. Martin.
Yes, sir.
All right.
Morning, sir. You're charged with a number of offenses. I cannot set bond on the trafficking of methamphetamine charge, but I have set bond on the other offenses. You have a $3,000 bond on the VGCSA simple possession, a $1,500 bond on possession of marijuana less than an ounce, $5,000 bond on the possession of firearm or weapon during a crime, commission of a crime, a $5,000 bond on possession of a firearm by a convicted felon, $5,000 bond on theft by receiving stolen property, and a $3,000 bond on the other possession count. You're going to have a preliminary hearing date set for November 24th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for December 3rd at 8:30 in the morning, also in courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer? All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back. Mr. McClure.
Yes, sir.
Sir, you're charged with one count of disorderly conduct. Bond is going to be set at $1,500, and one count of obstructing or hindering a law enforcement officer. Bond is going to be set at $2,000. So that's a total bond of $3,500. You believe you can post that bond?
Is it possible I can get a reduction?
No.
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. McCoy. Mr. McCoy, sir, you've been charged with possession of marijuana less than an ounce. This is a misdemeanor offense. Bond is going to be set at $1,500. You've also been charged with driving a vehicle with license not on person. Bond is going to be set at $500. So that's a total bond of $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify, Mr. McCoy. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
When I'll be going to court, like, in violation of probation? Cause that's why they locked me up. It's had one.
I'm sorry, say that again.
I'm asking like, when will I be going to court for my violation of probation? That's why they locked me up. They said I had one.
That would have to go back before the judge that placed you on probation. So do you know what judge that was?
Matthews.
Was it Judge Mack?
Yeah.
Okay, so Judge Mack would be the person that your lawyer or family member would have to get in contact, not with the judge directly, but with his office. And they would be responsible for placing your case on a calendar to deal with the probation. They may have placed a bond on the warrant. So I don't know any of that. I don't have access to that, but I know because of COVID times, some judges now, when they issue a warrant for probation violation, they place a bond on it. So you get arrested, but you can go ahead and pay the bond without having to go back before the judge.
All right.
Okay?
Yeah.
All right, sir. You're free to go back. Mr. Means.
Morning, Your Honor.
Good morning, sir. You're charged with one count of possession of marijuana less than an ounce and one count of an open container violation. There's going to be a $1,500 bond on the possession of marijuana. There's going to be a $500 bond on the open container violation. So that's a total bond of $2,000. Do you believe you can post that bond?
Yes, sir.
Both of these are misdemeanor charges. So you're going to have a preliminary hearing date set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh, good.
I'm sorry, sir.
Yes, sir. Good. Yes, sir.
Okay. you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. No, sir.
Okay, you're free to go back. Mr. Nicoli or Nicolai.
Yes, how you doing, sir?
I'm doing well. How do you pronounce your last name, sir?
Nicole, sir?
Okay, Mr. Nicoli, you've been charged with 1 count of possession of marijuana over an ounce. I've set the bond at $5,000. 1 count of possession with intent to distribute. I've set the bond at $5,000. 1 count of possession of a weapon during the commission of a crime. The bond is going to be set at $5,000. 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. 1 count of obstructing or hindering a law enforcement officer. Bond is going to be set at $2,000. And finally, possession of marijuana less than an ounce. Bond is going to be set at $1,500. So you're going to have a total bond of $20,000. Do you believe you can post that bond?
Is there any way I can get a bond reduction?
No, sir.
All right.
Okay. So your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I do have a question, but I don't think you can answer that during this first appearance.
Ask the question and I'll tell you if I can answer it or not.
Okay, so if you know how you said the firearm charge, right?
Mm-hmm.
What if somebody write an affidavit saying that is theirs?
So depending on where the weapon was, possession doesn't have to be actual. It can be constructive. And so if it's...
I'm sorry about that.
So because this is saying it was inside of a vehicle,
Right.
Everyone can be charged within the vehicle with possessing that weapon.
Right.
Now, whether a person can ultimately be convicted of it is something different. So if someone says, hey, that was my gun, then depending on what the officer has to say about what happened, then they may say, well, hey, we're going to drop that charge. Or the prosecutor may say, nope, I'm going to go forward with the charge. Okay. So it's like there's a, because everybody can say that's not my gun.
Right.
So it doesn't necessarily, that doesn't end the conversation.
Right.
Okay.
I know it don't end the conversation. I just, you know what I'm saying, don't want that charge against me because if I know it 100%, it ain't mine.
Yeah, and again, ownership does not equate to possession. Okay, so you can hand me a gun and I'm possessing it, but it's not my gun, it's your gun. Okay, so that's something you have to speak to your lawyer about. Okay.
All right.
All right, sir, you're free to go back.
Hey.
Was it Oliver? Who did you just call?
Oliver.
Okay. Mr. Oliver, sir, you charged 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
I know, sir.
Okay. Your preliminary, you know what? I'm going to set this bond at $1,000. I shouldn't have set it at $3,000. It's going to be $1,000. Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
What was that court date again?
November 23rd at 8:30 in the morning, courtroom 201. But once you bond out, that date will get changed and you'll get a new court date in the mail.
Thank you, sir.
You're welcome. Mr. Wilson. Oh, sorry, Daquan Wilson. Mr. Wilson, sir, you've been charged with one count of theft by shoplifting. This is a misdemeanor. Bond is going to be set at $2,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for November 23rd at 8:30 in the morning, courtroom 201. That date will get changed upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, thank you, Your Honor.
I'm sorry, sir.
No, thank you.
You said no, thank you.
Yes.
Okay. Do you have any questions of me?
No, Your Honor.
Okay, sir, you're free to go back. Mr. Quamaine Wilson. So you're charged with one count of possession of marijuana with possession of a controlled substance with the intent to distribute. Bond is going to be set at $10,000. One count of possession of marijuana over an ounce. Bond is going to be set at $5,000. And one count of use of a firearm by a convicted felon during the commission of a crime. Bond is going to be set at $10,000. All of these are felony offenses. So you're going to have a total bond set at $25,000. Do you believe you can post that bond?
Yeah.
Your preliminary hearing date is going to be set for November 24th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. Well, let me ask you this. How much do you earn per hour?
What you mean? What you mean, sir?
You checked on the form that you had a job, but then you didn't place how much you make.
Yeah, because I can go back and work with them. I don't work with them right now though.
Okay, so are you currently not working?
No, sir.
Okay, I'm gonna find that you qualify. I'm gonna appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. John Haywood.
Yes, sir. Good morning.
Good morning, sir. You are here on what we call a fugitive from justice warrant. And what that means simply is that there's another state that has a warrant for your arrest, and you have been arrested on that warrant. So it says that you're wanted out of New York. And I'm not going to say what the charge is, because I would presume that you know what the charge is. Is that correct?
Yes, sir.
Okay. So you have a right to demand a hearing on what is generally called a writ of habeas corpus, which just basically means produce the body. At that hearing, a judge in Clayton County will determine whether you are the person named in the warrant and whether the warrant actually exists. If the judge finds that those two conditions exist, the judge will sign off on the writ or the governor's warrant and have you sent back up to New York. Now, the timing of that in Georgia, that hearing will be sometime within the next 90 days. Okay. And if the judge finds that those conditions exist, the judge will issue the writ, and then state of New York has an initial period of 30 days to come and get you. They can request an additional 30 days if there's something that happens. If you believe that you are the person named in the warrant and that the warrant is valid, you can waive that process today. And then if you waive that process today, the state of New York, that time period of the 30 days will begin to run today. And if they don't come and get you within the statutory period, the sheriff's office will release you. But that doesn't mean the charge goes away. So you can be released out of the front door and encounter a police officer 5 minutes after your release, and they run your information and they see that the warrant is still valid, and then the process starts all over again. So am I making sense to you?
Yes, sir. I understand clearly.
Do you have any questions?
No, sir. I would like to waive it and start.
Okay. Okay, so the deputies will give you the forms and you can sign those. And when you sign them, they'll send it to me and the clock will start to run today.
Thank you, sir.
You're welcome. And Mr. Valles or Vales, he said that his warrant out of California, he was given a bond on it, or so we don't have to deal with him.
That's correct. You don't have any charges here, from my understanding. They withheld the hold on, from my understanding.
Okay. All right. Well, thank you for your assistance. Have a good weekend, and
too, sir.
We'll start it all over again on Monday.
All right. Have a good weekend.
Okay, you too.